Hello, my name is Izznayli Nur'asyrani binti Asli and my student ID is 0360536. Today I will be discussing on why trustees are fiduciaries and the modern relevance of trusts law. Before moving on to today's discussion, I will be dividing my video into 6 parts. First is introduction, which is fiduciary duties and its principles. 2, the Malaysian position of fiduciary duties. 3, the duty of care. 4, accountability. 5, the impact of commercial trusts. And lastly, I'll be concluding my discussion. Firstly, introduction. What is a fiduciary duty? As defined in Bristol, West and Matthew in 1998, Millet Lord Justice had defined fiduciary duty as the trustee's duty to not place themselves in a position of conflict with the interests of the trust and his duty not to make unauthorized profit from the trust property or from his position of trust. In defining fiduciary duty in the context of company directors, this definition is taken from the case of Towers, whereby the rules governing the fiduciary duty is to avoid conflict as being simple, strict, and salutary. What are the duties of a fiduciary position? The duty of good faith, whereby a trustee must exercise his powers and discretion in good faith for purposes of the trust. 2, the no profit rule. A trustee must not profit from their position unless authorized by the trust, statute, or court. And 3, the no conflict rule. A trustee must not be in a position whereby their personal interest conflicts with beneficiaries. Moving on, discussing the 2 equitable principles of a fiduciary. Number 1, the no profit rule. Lord Herschel and Brainford in 1896 discusses that the no profit rule is an inflexible rule of the court of equity that a person in fiduciary position is not, unless otherwise expressly provided, entitled to make a profit. He is not allowed to put himself in a position where his interest and duty conflict, and thus prejudicing those whom he was bound to protect. Whereas by the no conflict rule, established in the case of Keach and Stanford 1726, Lord King had pursued a strict application of the no conflict rule in which a trustee must not obtain benefit which would conflict with his own duty. And this again was established in Boardman and Phipps in 1967, whereby a person in fiduciary position must not utilize any information which has come to them due to their position to gain a profit. Conclusively, a trustee holds the position of fiduciary duty in a settlement trust because the trustee has legal title and exclusive control over the trust property, creating an inherent power imbalance that requires the highest standard of loyalty to prevent abuse, hence why trustees are classified as fiduciaries. In discussing the Malaysian position of trustees as fiduciary duties, we must first understand that Malaysia operates a dual legal system, which are laws for Muslims and non-Muslims. The trustees' fiduciary duties are not explicitly defined under the Trustee Act 1949. Under the Civil Law Act 1956, due to the absence of local legislations, reliance is made to common law principles. In defining what is a fiduciary relationship, this definition can be found in the case of Tun Dr. Mahathir bin Muhammad and Datuk Seri Muhammad Najib bin Tun Haji Abdul Razak, whereby a fiduciary relationship would only arise when there is a mutual trust and confidence. It is out that this relationship that the fiduciary is obliged to act solely for the other party's benefit, above and over their own interest. Another example in defining a fiduciary duty can be found in the case of Ka Cheng Bok in 1998. In this case, executors were found having to want a proper capacity to execute their duties of honesty and reasonable fidelity, such as by taking remuneration. However, in Section 35, Subsection 2 of the Trustees Act, it does not include remuneration for trustees' care and trouble. Under Malaysian law, easily that personal representatives, or otherwise known as trustees, undertake the critical role of fiduciary duties in inheritance management by ensuring honesty, integrity, and fairness. As for Muslims, inheritance matters are governed by Sharia law. The distribution of a Muslim's estate and allocating shares to their heirs is based on their relationship to the deceased. The power of trustees for Muslims is scattered in several provisions, and this can be found in several provisions such as the Islamic Family Act 1984, Guidance on Non-Islamic Trust in Labuan, Labuan Trust Act 1996, Muslim Wills Selangor Enactment, or otherwise the Public Trustee Act 1949. As stated by Yusinta Yusof, the duty of the trustee is to manage the trust property, to sell, buy, or lend the property for the benefit of the beneficiary as long as it does not result in extreme or excessive loss, grave or overreaching deception. Essentially, The status of a trustee as a fiduciary is a fundamental principle of equity. It is imposed to safeguard the beneficiary's interests against the trustee's power and potential for abuse, ensuring the trustee's single-minded loyalty. Moving on to the duty of care owed by fiduciaries, the no conflict rule, and company directors. In old law, this can be found in the case of Regal Hastings and Gulliver in 1942. So in this case, the directors had invested a capital through Regal's shareholders and sold the subsidiary shares to a purchaser to obtain 2 available cinemas. Regal had took action for the profits made on the subsidiary shares, and the House of Lords applied the rule in quiche whereby who by in fiduciary position, the profiteer, however honest or well-intended, cannot escape the risk of being called to account. In this case, it is shown that there is a strict application as to accountability taken towards company directors who are in fiduciary position, whereby their personal interest must not conflict over the beneficiaries of the trust. However, in the case of Peso Silver Mines and Croppers 1966, the Supreme Court of Canada held that a director was not liable to his company for acquiring mining properties and profitably exploiting them when they had been previously offered to the company. The board of directors were bona fide not to take up the offer. And in the case of Canadian Aero Services, Laskin Justice had reviewed the English Commonwealth and listed factors considering the scope for breach of fiduciary duty. And this list consisted of factor of position, nature of corporate opportunity and the director's relation to it, knowledge possessed by the director, and the factor of time and continuation of the fiduciary. In questioning the trust law duty of loyalty, whether it is for sole interest or the best interest of the company, John Langben in 2005 argues that the no conflict rule in Keach should be flexibly applied so as to not discourage entrepreneurial risk-taking or business opportunities that would benefit the company. In complementing the fact-finding ability of modern courts, the strict rule should be abandoned in favor of case-by-case basis. Assessing the strictness of the no conflict rule application, we now see it's still being strictly applied in commercial contexts. So in commercial expediency against the strict loyalty rule, this was again affirmed in the case of O'Donnell in 2009, whereby the strict application of the no conflict rule is still used in the context of business opportunities. In this case, the directors have a duty to disclose and acquire companies' informed consent before making profits. If they fail to do so, directors breach their fiduciary duty. Hence, directors are classified as fiduciary trustees who must disclose any information or business opportunity that may be crucial or beneficial to the company, vice versa, and discuss it with the company before proceeding with any personal transactions to discharge from liabilities. So we can see here that even in modern contexts, the strict rule application is still being applied. However, there is a little leniency whereby the fiduciary trustees must disclose any information or business opportunity to the company before making any decisions. Now we discuss on accountability, whereby modern trust law codifies duties of accountability. In old law, accountability was measured through equitable remedy. So in the case of Job in 1877, accountability was through equitable remedy of compelling an account from the trustee. There was no obligation for the trustee to volunteer information to beneficiaries unless specifically requested, and the scope of what information can be disclosed was often debated. Hence, the old principle of equitable remedy through compelling an account from the trustee had hindered beneficiaries from compensating their claims. Nonetheless, now in modern law where there is statutory framework, in example of Malaysia, trustees' accountability is measured through legal and regulatory requirements. This includes financial reporting and compliance, such as in the Trustee Act 1949. Another example is the Securities Commission of Malaysia in 2012, whereby they regulate internal governance, reporting, and duties of trustees for the beneficiaries and the public, ultimately leading to new provisions for investor protection and corporate governance to oversee new entities. The Securities Commission Malaysia would oversee and enforce laws for fund management, companies to disclose interest, information, holdings of clients and beneficiaries. And they would also enforce anti-money laundering laws in preventing money laundering and terrorism financing, which mandates disclosure and registration of beneficial ownership information. With regulations outlined under the Securities Commission, such as transparency of accounts and strengthening board governance, trustees now have increased supervision when assessing their accountability when there is breach and compensation owed to the beneficiaries. Now we move to the impact of commercial trust. With the rise of commercial trusts that have tested and refined fiduciary duties owed by trustees, the UK Law Commission states that those who create trusts in commercial dealings do not require the same protection as those who create traditional family trusts, as there are different considerations raised in the commercial context. However, it is best to note that the core duty of loyalty and acting in good faith for the benefit of beneficiaries remains, and this was established in the case of Armitage, whereby the standard of dishonesty would also apply to commercial trusts, as there is still a duty to act in good faith for the trustees. Complexities of commercial trust arises whereby there is an increased complexities due to commercial realities, which often require professional expertise. And Stephen Gagler states that in managing complex commercial assets, trustees must have the necessary skills and advice. This expands to business strategy, ECG considerations, and overall investment policies set out in the trust deed. In the Malaysian position, we can see a business trust, which is a new asset class introduced into the Malaysian capital market after the creation of the Securities Commission Malaysia's Business Trust Guidelines in 2012. A business trust would operate and run an enterprise, but it is created through a trust deed, which the trustee has legal ownership of the trust assets and manages the assets for the benefit of the beneficiaries. However, this form of commercial trust has increased the higher standard of care and precedents required for trustees as fiduciaries under modern law. So as to conclude, the fundamental principle of fiduciary duty for a trustee is rooted in the equitable rules of no conflict and no profit, demanding undivided loyalty to the beneficiary's interests as strictly upheld in the seminal case of Keach and Stanford. In Malaysia, while not explicitly defined in the Trustee Act 1949, these duties are enforced through common law, equity, and a growing statutory framework such as the Securities Commission Malaysia regulations to ensure accountability and integrity. The traditional approach has developed to enhance modern law, especially in commercial trusts and corporate directorship, with the core duty of loyalty, but introduces a more flexible standard of care, emphasizing disclosure and informed consent to adapt to complex business realities, ultimately upholding the trustees or fiduciaries' paramount obligation to act in good faith and for the sole benefit of the principal.